Most crimes require that the defendant have some type of mens rea, or guilty mind. But is it enough that the defendant should have a guilty mind under the circumstances? Or does the defendant actually need to have a guilty mind? The Maine Supreme Judicial Court answered this question in State v. Beale. Elery Beale owned an antique shop. One day, while Beale was away and Beale's wife was watching the shop, a customer came in with a police officer. The customer claimed some of the items for sale in the shop had been stolen from her home, pointing to her initials on some of them. The police officer asked the Beales to hold the items on a special shelf and not to sell them while the woman's claim was under investigation. When Beale returned, his wife told him about the customer's claim and the police request. The next day, Beale sold many of the items, including all the items that allegedly had the woman's initials carved into them. The police learned about these sales, and Beale was charged with concealing property that he knew was stolen. At trial, Beale argued that he hadn't believed that the items were stolen. Beale had purchased the items at different times from different people whom Beale considered reliable, and he'd received receipts for these purchases. Beale believed that this information meant that the items weren't stolen and that he was their lawful owner. Beale requested a jury instruction stating that he was guilty of knowingly concealing stolen property only if he had personally, subjectively known or believed that the items he sold were stolen. The court didn't give that instruction. Instead, over Beale's objection, the court instructed the jury that Beale was guilty of knowing that the property was stolen if either he personally, subjectively knew that the items were stolen or a reasonable person in Beale's position would have known that they were stolen. The jury found Beale guilty. Beale appealed to the Maine Supreme Judicial Court.